Most landlords hire a third-party consumer reporting agency that pulls from county court records, statewide criminal databases, and sometimes federal sources. That means a booking record can appear on a report even before your case goes to trial. The important legal distinction is between an arrest record, a pending charge, and a conviction. All three can potentially show up, but California law treats each one very differently. Under California's Fair Chance Act, which took effect in January 2020 under Assembly Bill 1076, landlords with more than one unit are generally prohibited from asking about your criminal history on the initial application. They can only run a background check after they have given you a conditional approval. And if they decide to act on something they find, they must follow a formal adverse action process that gives you a window to respond in present context. This does not mean a landlord can never consider a DUI, but it does mean they must follow a specific legal process before acting on it. A bare arrest that did not result in a conviction generally cannot be used against you in a California housing decision. If your case is still pending, you have not been convicted of anything. If charges were never filed or the case was dismissed, that arrest should not be held against you by a landlord. Knowing exactly where your case stands and being able to document that status in writing can make a real difference when you respond during the adverse action process. A letter from your attorney or a certified court printout showing no conviction has occurred can carry significant weight. If your case is dismissed or you are found not guilty, you may be eligible to have the arrest record sealed under Penal Code 85191. That statute lets a court order the record treated as though the arrest never occurred for most purposes, which directly helps with background checks. Separately, if you are convicted but later pursue expungement under Penal Code 1203.4, landlords in California are generally not permitted to use that expunged conviction to deny you housing, though it can still appear on some reports. These are two different tools for two different outcomes, and both are worth understanding early. Many people with a pending DUI arrest assume they will automatically be denied and stop applying altogether. That assumption can hurt you more than the record itself. California law gives you procedural rights, and not every landlord will find or act on your arrest record. Use the fair chance process when it is triggered, and be prepared to respond. The documentation you gather for your criminal defense, character letters, employment records, and case status paperwork can also serve you well when a landlord raises the issue during the adverse action process. Your housing options are worth protecting, and California law gives you more tools than most people realize. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.